Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
This is Serious Privacy by TrustArc. Here are your hosts, Paul Breitbart and Kay Royal.
The start of this new year has been busy, both for Kay and myself, with a lot of changes in our personal lives. You will hear more about that during this episode. But of course, we'll also continue to follow up on all the privacy news and all the things that are happening in our community. In this week's episode, we'll continue the conversation on the IAB Europe decision by the Belgian Data Protection Authority. We talk about the right of access, and I go on a bit of a rant on international data transfers once again. My name is Paul Breitbart.
And I'm Kay Royal, and welcome to Serious Privacy. So, Paul, shall we just get the unexpected question out of the way to begin with?
Sure, let's.
If you could add 1 hour to your day, what would you do with it?
Ooh, well, sleep is always a good option. Eat is always a good option. But right now, probably work would be the preferred option because there is so much to do, both at Katowice and for all the other things that I'm doing. And still coming to terms with finding a new rhythm in my week. Yes. When you've been working 5.5 years across time zones and suddenly everything is in the same time zone, apparently that also requires an adjustment.
You know, you and I talked about you having to do that to adjust to operating during normal business hours with the new job. So that's fun. And you know, as I asked the question, as I was writing down in my book, my answer was sleep. But it's really not. I don't know what I would do with an extra hour.
Well, you would probably make a new costume for your next cosplay event or something like that, right?
Probably, because we do have Comic-Con coming up in May, and I haven't made that costume yet. I have one in my mind that we're going to do. But yeah, so the other thing I was going to say, though, is this week, if I had an extra hour in my day today, it would be catch up on whatever's going on in privacy. Are you and I matching today, too? Are you wearing a black sweater or a dark blue one?
No, it's blue.
I was going to say, I'm wearing black and white, and it looks like you are. Okay. But it would probably be catch up on everything. Because last week I was on vacation competing in one of my pageants, and I barely touched the phone, only to take pictures and, text message people. Never opened the computer. I have no idea what's going on. The European Union could have completely dissolved, and I would have no idea right now.
Well, you have heard that there is something going on in a country called Ukraine at the moment?
That I did hear. I did hear. Is that affecting? What is that doing to y'all?
Well, it's a scary situation having another war It's a scary situation having another war emerging so close to home. But yeah, let's see whether diplomacy can still do something. I don't know.
It's very interesting.
It's a strange situation.
It's especially interesting with what we hear over here versus what I expect y'all are experiencing over there.
Yeah, but it's. I think it's too early, at least for here in the Netherlands, to really experience something. But it will come over time.
Or not. I hope not.
Well, yeah. Of course, I hope not. But I'm not so sure at the moment.
Yeah.
And of course, also from a data protection perspective, this is going to be interesting. What effect will war have on data transfer risk assessments, for example? We've also not looked at those kind of things. What will happen with personal information in Ukraine if the Russians invade? And all those kind of questions also, well, maybe we'll revisit that at some point in the future when things really go wrong, and at the same time, when we release this episode, we don't know what has happened in the interim.
Right, right. Well, and I will say that over here in the U.S., I mean, we're pretty protected. We're pretty insulated from a lot of things because, I mean, 9/11 was pretty significant in the fact that someone brought the war to the U.S. Other than that, we don't live in fear of being drugged from our homes or armies marching through or being under tyrannical rule, other than in a diplomatic or a democratic process.
Well, I mean, insurrections from within, you've seen those last year, so...
Yes, we did. I guess that was, that was unusual. Very, very unusual.
And of course, Happy Palindrome Day.
Yes, Happy Palindrome Week.
You need to explain the week to me.
So,
I know the day.
Well, because of the way you put your months and your days. So for us, it is 2/22/22, or 2/21/22, but 2/23/22, 2/24/22. They're all palindromes to us this week, but that's because our dates are weird.
Yeah, they are. I mean, this is just 22 to 2022. 22. This is just 22/02/2022.
Exactly. So regardless.
Or it is 22 to 2022, which especially tonight at 22 minutes past 10 at 22:22 will be really interesting. Again, your times are weird as well because you don't do 24-hour date format.
Well, it depends. A lot of people are on military and they do use the 24 days, the 24-hour time
sensible
frame.
People.
Coming from an Army brat family, yes. Very, very common for 24-hour increments. So, our listeners may be wondering, are we ever going to actually talk about privacy during this podcast?
Well, we are, and my first question is actually to you, because what are you doing right now? You haven't told our listeners your news yet. You have said in our last episode that you would be unemployed for a couple of days, alluding to something. You've shared something on LinkedIn, but our listeners have not heard from you.
No, that is true. So I have left TrustArc full time. You and I will continue with the podcast. TrustArc is sponsoring us. But I am now the lead privacy counsel at OutSchool. So it's really fascinating to be able to bring so many of my different interests to bear. But I will also tell you it's a different world being the privacy counsel for a company versus being, I'll just leave it as privacy counsel as opposed to other titles at TrustArc, which also encompassed, being the business owner for the product under development. And so at TrustArc, I never had to worry. I had to know about COPPA. I had to make sure that we could support customers with COPPA, but I didn't actually have to implement COPPA at TrustArc. And so that's an interesting dynamic that I'm in now as well. But I started the week and then they let me have my vacation and then here. So it's like you with Katawiki. It's getting up to speed on the company and what they do and how they operate and what processes do they have in place. And frankly, OutSchool's not bad. It's not bad at all. And for those of you that might not be familiar with OutSchool, they're an education provider, but not a school provider. They provide other education programmings. The new people had to say which class they would take, and so the one I found was weekly Disney princess parties. They didn't have Maleficent parties. And when I shared that, everybody's like, well, if you don't see it, make it. So who knows? Okay. I may run weekly anti-Mal storytime parties. But
so you... Basically, OutSchool gives education courses online. Is that the way to...
You can learn Mandarin. You can have Disney princess parties. You can learn to play guitar. You can do one-on-one tutoring. You can learn how to play video games. I mean, it's all over. It's fantastic.
And this is U.S. only, or is this global? This is,
because they're online, they're globally available, but they have focused on the U.S., and so now they are looking at purposefully expanding outside North America. I guess they've been U.S. and Canada, but they're looking at purposefully expanding now to other countries. And it's pretty fascinating. I hear so many positive things about them from everyone, and they're considered an ed tech unicorn, which I had to look up what is the definition of a startup unicorn.
That's $1 billion, right?
$1 billion. So they're valued at $3 billion. And they've expanded 900% over the past couple of years. And of course, that may or may not be complete. They got to see if that's sustainable, once the world goes back to normal. But we kind of have normal, and they're still growing astronomically. So I imagine that it's definitely going to be sustainable.
And this is mainly personal data from children, or is it all ages?
They focus on children, but the teachers and everybody, of course, are adults. And so you've got personal information from the parents or the guardians as well as the teachers. They're also looking at offering this as benefit to companies if they want to purchase OutSchool for their employees to be able to use for their children, which I think is phenomenal. They also partner, they have a foundation side, so they also partner with groups like Big Brothers, Big Sisters, things like that. So I'm really excited about this. It's kind of crazy. It broke my heart to leave TrustArc.
Yeah, I remember that feeling from last year.
Yeah, it really did. And by the way, this has absolutely nothing to do with my belief in TrustArc as a company and what they're doing. I absolutely still support TrustArc and what they're doing and how they're growing.
It was just time for a new challenge for both of us.
Exactly.
And so you get to also deal with fun issues like parental consent.
Yes, parental consent and explicit consent and things that I didn't even realize. I guess if I'd thought about it, I would have realized it, but content moderation. With children sharing information that perhaps they shouldn't be sharing.
Phone numbers, addresses, and...
Yes, exactly.
More sensitive stuff.
Well, and then teachers wanting to use third-party software in their classes, that this third-party software or third-party sites might not have been vetted. But of course, they're independent contractors. They can use what they need to use in a site unless it's been reviewed and said, no, you absolutely can't use this. But, there's the one extreme of these are absolutely approved and the extreme of these are not approved. And then 95% of everything else is in the middle, somewhere in between. So a lot of challenges that I never thought about, but I am definitely up to the challenge and I'm excited.
That sounds good. And how many new acronyms have you learned already?
Not very many, believe it or not. Not very many. But I will say they've been using Susan Hensey of the Hensey Law Firm because Susan is the one that I heard about the job from when she advertised it on LinkedIn or shared it on LinkedIn. And I absolutely love Susan Hensey and their boutique privacy law firm. And I respect the heck out of what they do. Always have. I think they're fantastic.
So it sounds like you're having fun, even though it's only been, your 7th day at work, 6th day at work?
Something like that, because they were closed yesterday. We had yesterday off as a holiday for President's Day. So, which was nice after coming back from vacation to have a day to be able to leisurely sit and read and review lots of different things in order to go back to work today. But yeah, it's a great company. I'm looking forward to it. So everyone that is probably a fan, if you hadn't learned about it, feel free to reach out. I think it's awesome. And thank y'all. And don't worry about it. Paul and I are here to stay for, they say year 3 is jumping the shark for podcasts. So we either succeed or fail this year.
Well, I think we are doing fine. And if I look at the numbers, they are still going up. We have a great season start. And of course, the episode we released last week with the Belgian DPA has been very popular. Even though it was a short one, I think it was in a very concise way. Everything everybody wanted to know about the IAB Europe decision. So that was a great start. And
although we didn't pry any state secrets out of them.
We did not, but it's...
we tried.
We tried very hard, but we did not succeed. And we'll have...
Very, very professional.
We'll have some more great guests coming up in the next couple of episodes. These weeks, as you may also understand, both Kay and I starting new jobs and adjusting to new schedules and vacations and all of that. We've held off a little on inviting guests to the podcast because we were not even sure that we were able to make our own episodes. So,
but we do have some great ones that have agreed to come on the show. We're just scheduling the time. So the one that comes to mind for me is Kurt Nara.
Mm-hmm.
We're going to have him on the show, I believe, in March, which, March is next week. But sometime in March, we're going to have him on the show. I'm very, very excited about that. He's the first one that comes to mind for me. I know you've got some excited one.
Yeah, I'm very excited that we get Shura Nass from Privacy Company. She is the lead on a lot of the DPIAs. There was another one released today, which we'll talk about next week, very likely, on all of the Microsoft software that is used by the Dutch government and the Dutch education system. Privacy Company is employed by the Dutch government to conduct all these very in-depth, technical-driven DPIAs and then also negotiate with the contracting parties on the remediation. So they've done Office 365, they've done Google Workspace, and now they've looked at Microsoft Teams and Microsoft OneDrive and all of those kind of issues. And all of those reports, including the remediation, are public, which is also a huge benefit for a lot of companies. So we'll talk about that in detail during our next episode.
And that reminds me of Victoria Beckman, which is one of my favorite law students. She is left a law firm. She's now at Microsoft as the head of their cyber crimes. I can't remember if it's limited to Latin America or if it's in general, but I'm very excited about having her on the show as well. So yeah, we've got some fabulous guests lined up. Just give us time to get to them.
Absolutely. And in the meantime, you will also hear more about our own struggles of going in-house as privacy counsels.
I have a feeling you've got a lot more stories around that than I do.
Well, I don't have a lot of stories, to be honest. I do have a lot of fun experiences. And I've also had my first data breaches to report, obviously.
Oh, no.
And the first data breaches to assess. Well, I mean, any large company where you work with a lot of people with a lot of personal data, things go wrong. And you may need to report something. So, and I've also done my assessment of lost phones and lost laptops and things like that to see whether that they had to be reported in those situations. And luckily we have all kinds of encryption and tracking. Not tracking is not the right word. Logging software, so you can actually see whether a machine was used or not.
Very nice.
Which helps to also assess and identify any risks that may have occurred.
So tell me, Paul, since I've been out of touch for about a week, what is going on in the privacy world? Anything new and earth-shattering that I haven't paid attention to?
Well, earth-shattering probably is the news today that apparently the Irish DPC has sent a revised preliminary decision report to Facebook.
Okay.
About the Schrems case.
Okay.
And allegedly, based on the media rumors, because of course the draft report is not public, but based on media rumors, it seems that the Irish DPC is going to prohibit all data transfers by Facebook from Europe to the US.
Ooh, she's cracking down.
Well, it seems like it, and of course Facebook won't agree. So there will be an appeals process, and we haven't seen the end of this, and there may be another court case before the Court of Justice of the European Union, but in any case, it seems that a decision is coming closer. So maybe by the summer, hopefully, we'll get a public version of the report.
That will be exciting to see.
I haven't seen a real timeline. So that's one. The other one...
I have heard rumors that we might have a solution to the Shield coming up.
Well, yeah, but those rumors have been ongoing since October, so...
Come on, I heard that there's a meeting they're going to have. Is it March or May or something that they plan to announce something?
So there will be a transatlantic tech council this time, I believe, in Europe, in any case in France, because they hold the EU presidency this half year. And possibly some sort of political deal could be concluded there. But I've seen more rumors pointing towards May for a political deal, which still would mean that there will be months before it can be operationalized. So before anything is final, it won't be until the end of the year.
Okay. We'll just keep these rumors going. You know what? We should make up a rumor. There are so many rumors on Privacy Shield. We should make up a rumor and then do some sort of unofficial social experiment to see how far the rumor goes.
Well, maybe for the new name, as soon as there is a deal that we can...
Lord
do
help
something
us,
like
right?
that.
But
so that's the second news. The third one The main one is that Grindr has appealed the fine that was imposed by the Norwegian DPA.
Ooh, unusual.
They do not agree with the assessment in the case. So they don't believe that they have shared sensitive personal information with their advertisers.
But by the very nature of it being Grindr's users, isn't that sensitive personal information, or are they...
Not according to Grindr, no.
Because you can't prove it. All you know is they're a user of Grindr?
Yeah. And I think that the Norwegian DPA's interpretation of the law is actually the right one. But, appeals are only helpful to further clarify the body of law that we have.
That is true.
Just like the IAB is also looking at whether or not they will appeal the Belgian decision. Because also there, they don't agree. And they've put out a lengthy Q&A, actually, on their website with all kinds of statements on what they believe to be right and not right, and how they interpret the case. And somehow they still seem not willing to accept that they are indeed the data controller and that there are indeed things that will need to change. So it's a difficult one. And
I'm sure our listeners can hear the expression on my face right now.
I'm pretty sure too. Odia Kagan actually shared the whole list of arguments on LinkedIn, and one of them, there is actually one of the statements that I agree with. IAB said the TC string approach has not been declared illegal by the Belgian DPA, and that's true. I mean, we heard that last week from the Belgian DPA. It has not been declared illegal. It has also not been declared as the perfect way forward. But here they are right. But for the rest, the APD the Belgian DPA would consider legitimate interest to be an adequate legal basis for the processing of TC strings if users are informed about their preferences being stored in the form of a TC string and provided with a way to exercise the right to object to such storage or processing. This would require additional user disclosures and controls in consent prompts. I'm not sure that they actually understand that no legitimate interest is no legitimate interest. But
right. A lot of companies rely on legitimate interest a lot without actually explaining to people what it actually means. And I think it's a little bit of a word game to say we're doing this based on our legitimate interest in whatever, without explaining that a legitimate interest must be balanced with the individual's expectations and rights and everything they have.
And that balancing test must be documented.
It must be documented, but not only that, you can't consider their rights and interests, the individual's rights and interests from the perspective of you as a company, because you inherently have a bias that what you want is more important. You really do need to put yourself in the place of that consumer and say, would I consider this as a consumer that their interest is not significantly impactful to my own rights and interests?
Yeah, it needs to be the other way around. You need to start with the perspective of the data subject, of the consumer, and not of the company.
And if you have to, then pretend that you're a regulator and look at it from that perspective, because some people find it really, really difficult to put themselves in the seat of a consumer, especially if you're in different countries or different regions with different privacy laws. It might be really hard to do it. So put yourself in the perspective of a European regulator.
Yeah, that may help.
Maybe the German regulator, and pretend you were that.
Yeah, or in this situation, the Dutch Data Protection Authority, because they have announced, following the Belgian decision, that the IAB TCF can no longer be used in the Netherlands, even though the Belgian DPA...
I'm glad you brought that up.
...did not go that far yet. The Dutch DPA has said, we don't want to see them anymore. There is no formal statement.
That's what I was looking for.
Yeah, only media reports. But so far, there is still no formal statement. But they've been very clear in all of the main news media. The IAB TCF cookie banners, or IAB TCF based cookie banners, are no longer allowed in the Netherlands based on the Belgian decision.
The IAB's Trust and Consent Framework, if you're not familiar with it, TCF, which is what Paul's referencing. So that was one of the last stories I heard before vacation, was that the Netherlands had said, you know what, we don't care if they have 2 months to turn in a plan and 6 months to implement that plan. We're saying it's illegal right now.
Yes.
That you can't do it.
I believe there were a few other DPAs who have used similar wording already.
Yeah, we'll see if we can't find those news reports for y'all and make sure that we put them in the in the podcast description. That way y'all can look at those for yourselves. But yeah, no official statements, especially that I could find from the Netherlands, saying what it was. But I mean, the news reports have them, so how do they have them? So I like facts.
Well, fact, we have another new kind of DPA investigation here in Europe.
Oh, tell me more.
And that is the so-called coordinated investigation.
Yes.
You were already familiar with coordinated action, where all the DPAs look at a certain issue at the same time, like they do within the Global Privacy Enforcement Network, GPEN. For example, a quick scan of all kinds of privacy notices for websites aimed at children, which they have done in the past, but usually that was just looking at the facts and giving some public outcomes, public statements, but without a lot of real enforcement.
Right.
There was already the possibility that data protection authorities would join the investigation of other DPAs here in Europe, or at least monitor all the discussions. But now we also have a coordinated enforcement action by the EDPB on the use of cloud services in the public sector, which means, by definition, that all of the data protection authorities in all of the member states are competent because it deals with their own public sector.
Right.
And that means that there are 22 supervisory authorities across the European Economic Area that are participating, including the European Data Protection Supervisor. And all in all, they will assess over 80 public bodies, for all of them looking at the use of cloud services. And that could be all kinds of cloud services, but I think that it would mainly be email and hosting and document services, things like that.
Right. That is pretty fascinating, because I know that when they were looking at the Google Analytics cases that have come up lately, one of the things, and I think it was by the Austrian local government, which I've been meaning to follow up on that, because it was a temporary order that was in place to see if the lawsuit moved forward, if I'm not mistaken, and I need to follow up on that. But one of the things that came out of that was the fact that they published in their statement that they had the ability to assess this, because since it was not against Google directly, Google was only a processor, and therefore there actually wasn't a finding against Google, that they could do that even though there was a one-stop shop and Google would normally be under the Irish DPA. So I thought that was interesting, and I think that highlights what Europe is struggling with right now, is that this one-stop shop of having the preferred DPA, or not preferred, but the DPA that actually should regulate the company, isn't working out so well, especially with these companies that are so large that they're very active across all member states.
That's true, although for Google Analytics, I don't think that kite will fly, because Google Analytics would always be a data processor.
Right.
Or at least regarded as a data processor, which is not a trigger for the one-stop shop. So
right.
There, the national authorities would investigate companies within their national domains, within their member states, to look at their use of Google Analytics. So I think in that situation, it is slightly different.
Yeah, I agree.
And also for Google Analytics, we've seen more updates. I haven't read the case yet, but the French DPA now also has released a Google Analytics case, which apparently has gone through the consistency mechanism and has not received objections from the other data protection authorities, right. Which means that the new interpretation of Google Analytics being an illegal data transfer basically has been confirmed by all EDPB members.
Right. And I do find it interesting that in these decisions, and I think this is critical that people need to pay attention to, these are controllers in the EU that these decisions are following up with. And therefore it is a local, I'm doing air quotes here, people, a local controller exporting to a U.S. processor. Does the same logic hold sway if you're a non-EU controller that's export, that you're already in the U.S.? I mean, let's be frank, it's the U.S. that's the problem, people. you're already exporting to the U.S. because you're a controller in the U.S. Would the logic still hold sway that you are a U.S. controller with a U.S. processor? Because a lot of their decision is based on individuals not understanding that their data is going to the U.S., but if it's a U.S. controller.
To some extent,
Yeah.
that might give a different outcome. At the same time, if it is
I don't know if it's a different outcome. I'm not sure of that.
if it is data that is already that is coming still from the European Union and that is subject to the GDPR, I don't believe that the outcome would be different
Yeah.
because the data transfer risk assessment would not be different.
Yeah. But the data's already in the U.S., so I don't know that the outcome would be different, but I think there might have to be a different flow of logic to
Well,
get there.
that's the main debate that is now slowly starting across Europe, going back to that whole discussion about the risk-based approach. Does that exist, yes or no? And is it allowed, yes or no? Some still argue
Yeah.
that the court already has said as soon as FISA or the Executive Order 12333 apply, then the US is automatically a no-go whether there is a likelihood that the risk occurs or not.
Right.
Others, including myself, say no, the likelihood should play a role and does play a role in the whole assessment.
Right.
Also because FISA 702 is not always applicable. It only applies to electronic communication service providers.
But Google is an electronic communications provider.
Yeah, and for EO 12333, you never know if it applies because all of those scope decisions are confidential or secret. And the US capabilities are such that they can touch every cable around the world if they want to. So that is not only relevant for data transfers from Europe to the United States, but also for data transfers from Europe to the UK or from Europe to South Africa or to
Right.
wherever.
Right.
Even intra-EU, if it goes on a cable from France to Ireland, it could be touched by
Yeah.
the US intelligence services, in theory.
Or other intelligence services in Europe
Or other intelligence services.
that people aren't talking about.
No, but I mean specifically for Executive Order 12333. Then again, if you are talking about the monitoring and tapping of internet cable traffic, which 12333 is mainly intended for, then encryption could be a very good measure, end-to-end encryption. So if you can do that, then again, the likelihood of interception dramatically goes down.
Well, and I think it's not just the likelihood of the interception that needs to be considered. I think it's also, you look at the likelihood and then you look at the impact should that likelihood occur. And given the data that Google Analytics is collecting in most cases, the data that they're collecting, isn't that risky?
No, for analytics data, it's not. Plus, it has never been subpoenaed by any government, according to Google's own statements. But that is the big debate, I think, that we are going to have in the next couple of months.
Yeah.
In the academic world, in the privacy pro world, with the data protection authorities, probably at conferences too. Are we willing to conclude that in whatever situation data transfers to the US are a no-go from the European Union? Or do we still allow for some form of risk-based approach? And yes,
I think there has to be.
that needs to be a strict risk-based approach, and it needs to be a documented risk-based approach
Yes.
based on real assessments. But, well, I mean, you know my answer. I've written 20 pages about it too. So my answer is clear, but I really think this is a bigger debate where we also really need the regulators to speak up
Right.
and maybe also talk a bit about what they see as alternatives.
Right. Because
And
you can't rewrite the GDPR without literally rewriting the GDPR. It clearly supports a risk-based assessment.
it does. It does. And in the end, we are all about, the question is, do we undermine the level of protection of individuals? And that also is to do with the likelihood that that data is actually touched upon.
Yeah.
And that is one of the challenges that I currently have also with other EDPB opinions. Also, if you look, for example, at the new draft for the right of access.
Right.
Yes, to some extent, it is what we expected. It is very, very clear and very step by step. This is what you should do. This is what you should do. And at the same time, you think, is this real and is this realistic? Is this doable in every single situation?
Which there will never be that.
No, and still rereading it and chewing on it to see what I think about it. But sometimes it seems like there is a bit of a lack of realism within between the data protection authorities. And I think they sometimes maybe overlook the fact that one of the main points also in their job description is to facilitate the free flow of information. Rant over.
That doesn't seem to be top of mind.
Yeah.
Let's just be honest, that doesn't seem to be top of mind. So we're going to have to bring this to a close. I know that we've probably hit our time for them, but quickly, there's really not much to share on the U.S. front. If we're doing, our weekly update, there's not a lot to share on the U.S. front. We've got privacy laws introduced in the states. We'll see where they go. I'm more looking forward to the conversation about the new Privacy Shield, because I have to have faith there's going to be something. And I am working on getting Christopher Hoff on the show. So he would like to come on. He has said so, but it has to be cleared by the government. So we'll see. And go figure, I haven't heard anything back from Vice President Harris's office about coming on the show.
Well, anybody with context, feel free to help us.
Yes, right. Feel free to stand up and advocate for us. So we have that. But I'm looking forward to seeing what the developments are going to be. I think we're going to continuously wrestle with this EU-US problem, but we haven't forgotten the other countries out there. We're still watching China, but the Olympics are going on. We're not going to expect anything big during that time. We've got the new laws in Saudi Arabia and the United Arab Emirates that I think it's the UAE that we're still waiting on an actual copy of the law. I think we have a bootleg copy, though, so to look at. I think we do have that. And otherwise, we're just waiting to see what else is going to develop. Oh, by the way, did I miss it?
We were monitoring India, and India has now started a discussion about replacing the draft of the data protection law and splitting it in two, because maybe the combination of having personal data and non-personal data in the same law
complicated it.
Is not the best idea. Whether or not that will fly, we don't know.
We shall
and
see.
On that note,
note,
thank you for listening to yet another episode of Serious Privacy. If you like our episodes, please rate and review us in your favorite podcast app or on your favorite podcast platform. Leave us also comments in the programs. We love to read those. If you want to join the discussion, join us on LinkedIn, find us at Serious Privacy, or find us on Twitter at @podcastprivacy. You'll find Kay on Twitter as Heart of Privacy, and myself as EuroPolB. Reach out to us via email, via seriousprivacy@trustarc.com, or via info@seriousprivacy.eu. And we'll see you next week. Well, you'll hear from us next week. Goodbye.
Bye, y'all.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace, so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on Nimity research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.